Good evening and welcome back. I'm Teddy, and I am going to take probably another minute or two as I am checking the sound, getting everything set up just for you. Go ahead and grab a snack because we will probably be here for an hour plus. All right. Shout out to the mob, all my other bears. I call the grizzlies and the honey bears. Please hit the like on your way in. As a reminder, everything that I say here in this broadcast tonight is fair use commentary. Let's see if I can just take this off. Just checking some things out as I'm getting set up here. I guess I could play a little background music while I'm setting up. It's only going to take another moment or two. Let's see. Something relaxing. Go ahead and grab that snack. Oh, you thought it was going to be something like boring? Not tonight. I like this one. I'm sorry. It's kind of got a nice vibe, doesn't it? It's not the typical music that I start off with. Analyze this mess, you'll find out. Getting set up. I think I can go ahead and get started. Shout out to my moderators. Also, I see both of you, Vicky Black and Baby Juju. And thank you already, Fiva, for the $20 super chat tonight. Let me put it up. There we go. Fiva, a longtime listener and supporter of this broadcast. I thank you. And so does the mob, my other bears. So did you grab your snack? You'll have time. Because tonight, we're going to talk about and take a close look at a brand new filing. There were two today that just hit the docket in the Smith versus Robertson case. Let me just see if I can move this screen over. I'm setting up a couple of screens. Don't want to move that. Hang on. I've got it. Just moving one more screen here. All right. As I mentioned, just hit the docket in the Smith versus Robertson. Daniel Robertson, the defendant in that case, or this case that I'm going to show you, has filed what is listed as ECF 107, a motion for civil contempt, along with ECF 108, a supporting declaration, 5-page declaration under penalty of perjury, together with the attached exhibits. This filing totals more than 285 pages, closer to 290 pages. Now, whenever you see a filing this large, it is tempting to assume that more pages automatically mean a stronger case. I'm not saying, did I say fair use commentary? I put it in the chat. Let me just say it again as a reminder. Fair use commentary, everything that you hear in this broadcast is for education, criticism, news reporting, teaching, and analysis. I'm not here to say who is right and who is wrong. All right. Now, let me get back to this. Talking about it meaning a stronger case simply because, nearly 300 pages were filed. I'm not here to argue that. I'm just making a point. That's not how litigation works. A court doesn't decide a motion by weighing it on a scale. We've learned that. The question is whether the legal arguments are supported by the law and whether the evidence proves the facts the moving party is trying to establish. Sometimes 10 pages are enough. Sometimes 200 pages don't move the needle. That's for the court to decide. Danielle's motion is asking the district court to hold Kimberly Smith, the plaintiff, in civil contempt. More specifically, she argues that Kimberly violated the court's stay orders by accessing, downloading, backing up, printing, reviewing, investigating, and publicly displaying Google-produced materials after the stay went into effect. She also asked the court for preservation orders, a sworn accounting, and protective relief regarding those materials. The declaration that accompanies the motion isn't a legal brief. It's a sworn statement in which Danielle Robertson says she personally viewed the broadcast, preserved recordings, reviewed transcripts, and authenticates the exhibits attached to the motion. One thing that immediately stands out is the size of the evidentiary package. The motion itself is relatively short, almost 14 pages. The remaining pages consist largely of exhibits, screenshots, transcripts, and other materials Danielle believes support her request for contempt. Whether those exhibits ultimately establish a violation is a separate question for the court to decide. But she's clearly attempting to create a detailed, factual record for the court to review. Tonight, I'm not reading this filing to tell you who's right or who's wrong. Listen carefully. I'm reading it because if we're going to discuss a motion of this magnitude, we should start with what was actually filed, not with rumors, summaries, or social media commentary. We'll go through the motion section by section, examine the arguments Danielle is making, and later, when Ms. Smith files a response, we may give that filing the same careful review. So, with that said, we're going to begin with ECF 107, Defendant Danielle Robertson's motion for civil contempt. I want to remind you of a couple of things that I showed you from last night. These are the two quotes that came from the defendant directly. Let's see if I have everything set up here. This first one, the district court, I believe, is biased. And I believe that they know that they messed up on this case and they are not wanting to address my pending motion that I filed in May. Words spoken by Danielle Robertson, fair use commentary. Let me show you the second one that followed. I can file something today and they can already respond to it, but they cannot or they're not responding to what I filed back in May. Again, Danielle Robertson, fair use commentary. Let me just check the chat real quick. See if there's any message. You can also email me right now at unwinewithteddy@gmail.com. I'm going to put this up. Please be respectful and mindful in the chat. And that's my email address. And like I always do, for Analyze This Mess, let's begin. All right, we should be able to get through this. Um, as you can see, this is case number 224CV12213. This is ECF number 107 at the top, page ID 1692. That means there's been, at this point, 1692 pages filed in this case. This was filed today on the 16th, and it contains 285 pages in the United States District Court, Eastern District of Michigan, Southern Division, Smith versus Robertson, Honorable Lori Mickelson, and Magistrate Kimberly Altman. Motion for civil contempt. Defendant's motion for order to show cause, preservation, secure, sequestration, sworn accounting, and protective relief regarding Google produced materials. Let me just see if something. All right. How is the sound right now? Is everything still good? I switched off a couple of things. I don't want to go any further. Make sure. Good. Let's begin. Defendant Danielle Robertson, proceeding pro se and preserving all objections and appellate rights, respectfully moves for an order requiring plaintiff Kimberly Smith to show cause why she should not be held in civil contempt for violating ECF numbers 93 and 97. Defendant also requests immediate preservation, secure sequestration, a sworn accounting, and a protective filing procedure for non-public Google produced or production derived identifying and technical information. The court expressly instructed, quote, if plaintiff has violated the court's stay order, the proper recourse is a motion for contempt. That is ECF numbers 106, page ID 1690. Defendant now follows that instruction. This motion concerns a narrow course of conduct. Plaintiff's affirmative post-stay access, retrieval, downloading, backup, printing, review, investigation, public display, public use, continued retention, and threatened further disclosure of information obtained through post-judgment Google subpoena process, while enforcement of the judgment and discovery in aid of execution were stayed. Also, just because I'm reading this does not mean I agree with what is written within the pages of this motion for contempt. Okay. I continue. This motion does not seek to punish plaintiff for insulting defendant, criticizing court filings, reading public docket entries, or discussing parties' online dispute. Defendant contends that plaintiff's continued access copying, investigation, display, threatened disclosure, and proposed public filing of Google produced material after the entry of ECF numbers 93 and 97 violated or at minimum warrants clarification concerning the court's stay orders. Defendant recognizes that contempt must rest on conduct clearly covered by the court's orders. Defendant, therefore, does not rely merely on Google's transmission of an email. Defendant relies on plaintiff's affirmative post-stay conduct, secure portal access, retrieval, downloading, copying, printing, reviewing, identity investigation, public display, and threatened further dissemination as continued discovery in aid of execution or proceedings to enforce the judgment. Alternatively, if the court finds the prior orders insufficiently explicit as to any particular act, defendant requests immediate prospective clarification, preservation, sequestration, and non-disclosure relief. I am reading this, by the way, for the first time. Bear with me. The precise subpoena process that caused Google's production remains unknown. Google objected. A motion to quash was filed. Google was therefore advised that judicial relief had been sought and was provided the relevant stay orders. I pause as I'm thinking about that. Google was therefore advised that judicial relief had been sought and was provided the relevant stay orders. The court dismissed the motion to quash as moot because a stay was in effect and warned that any resurfacing non-party subpoena issue would require full compliance with Federal Rule of Civil Procedure 45, ECF number 85. Page ID 962 through 963. After that order, defendant received no advance copy. Defendant received no advance notice or copy of any amended, corrected, renewed, continued, reissued, transferred, converted, domesticated, California, replacement, or other operative Google subpoena. Plaintiff has given conflicting public accounts. She stated that she paid for subpoenas through other states and had to transfer the subpoena. She also described the latter or later Google communication as an extension or continuation of the April process. Recall I mentioned last night a corrected subpoena. I characterized it as corrected. Here, I'm just going to go back because I'm speaking outside of this. Plaintiff has given conflicting public accounts. She stated that she paid for subpoenas through other states and had to transfer the subpoena. She also described the later Google communication as an extension or continuation of the April process. Those positions appear inconsistent and require explanation under oath. You might understand why I needed to pause. Okay. I'm not here to argue the merits of the case. I'm reading these documents. But from time to time, I will pause and reread and may make a brief comment and share my thoughts. Okay. I continue. Whatever uncertainty exists concerning the earlier subpoena process, plaintiff's July 10th, 2026 conduct occurred after ECF numbers 93 and 97 and provides an independent basis for a show cause order and immediate protective relief. Let's go to this next section. Local Rule 7.1a, Concurrence Certification. On July 14th, 2026, defendant sought plaintiff's concurrence through email. The defendant explained that she intended to seek an order requiring plaintiff to show cause concerning compliance with ECF numbers 93 and 97. Plaintiff declined to concur on July 14, 2026. July 14th. Defendant sought plaintiff's concurrence through email. The defendant explained that she intended to seek an order requiring plaintiff to show cause concerning compliance. Got it. Plaintiff declined to concur. Let's continue. Brief in support. The next section. Issues presented. 1. Whether ECF number 93's stay of enforcement of the judgment, including discovery in aid of execution, and ECF number 97's stay of execution on the judgment or proceedings to enforce it applied to plaintiff's affirmative post-stay use of Google post-judgment discovery material. Defendant answers yes. And by the way, this section is bolded. 2. Whether plaintiff should provide a sworn accounting identifying the exact subpoena or process Google honored, what resolved Google's objections, whether Rule 45 notice was provided, and when each portal access, download, backup, printout, review, investigation, display, transmission, or proposed filing occurred. Defendant answers yes. I'm just having a thought. Were there more than one? That's why I called it a corrected extension. 3. Whether immediate preservation, secure sequestration, and a protected filing procedure are warranted even if the court reserves or denies contempt because the prior stay orders were not explicit enough as to a particular act. Defendant answers yes. And then in this next section, it's the controlling or most appropriate authority, which includes all of these federal rules and citation authorities. I'll just show them, but I will read this first. Federal Rule of Civil P 5.2, 26C, 45A and 4, or sections A4, 62A and 69A2. Federal Rule Evidence 106, 801, D2A and 901. 18 USC 401.3, ED, which is Eastern District, Michigan, Local Rule 5.3 and 7.1. And then the following citations, which are multiple. Maybe I could just read some of the names here. NLRB versus Banham. That was in the Sixth Circuit. Rolex Watch USA Inc. versus Crowley. NLRB versus Cincinnati Bronze Incorporated. Taggart versus Lorenzen. Macomb versus Jacksonville Paper Company. International Union, United Mine Workers of America versus Bagwell. United States versus United Mine Workers of America, and Goodyear Tire and Rubber Company versus Hager. Okay. We now come to the introduction. Let me pause and grab a bottle of water. Yeah. All right. So hopefully you grabbed your snack. I grabbed another water and I've had my Gatorade. Let's begin with this section, introduction. This is not merely a dispute over whether the original Google subpoena contained a technical defect. It is a motion to enforce two express stay orders. ECF number 93 stayed enforcement of the judgment, including discovery in aid of execution. ECF number 93, page ID 991. ECF number 97 stayed execution on the judgment or proceedings to enforce it. ECF number 97, page ID 1119. Plaintiff knew those orders existed. During the July 10th broadcast, plaintiff acknowledged that the stay was in and that once the court acted, quote, we had to stop. Exhibit B, transcript minutes 701 through 724. Plaintiff nevertheless admitted that she hurried to click Google's secure portal, entered a private file location, downloaded the production, created backups, printed the production, reviewed non-public information, conducted further investigation, and publicly displayed production-related documents. Exhibits B, transcript, timestamp 8 minutes 30 through 8 minutes 39 seconds. 13 minutes 57 seconds through 14 minutes and 6 seconds. 20 minutes 47 seconds through 22 minutes 5 seconds. 38 minutes 16 second through 38 minute 36 second. Exhibits A-2, A-3A through D, A-7, A through B. Plaintiff later stated, while discussing revealing defendant's identity, quote, that's not what I'm trying to do because it is a stay, unquote. Exhibits B-1, transcript minutes 1 minute 11 seconds through that's hours. That's at 1 hour 11 minutes 13 seconds through 1 hour 13 minutes and 31 seconds. That statement does not automatically prove that plaintiff knew every form of access or preservation was forbidden, but it supports an inference that plaintiff understood the Google production remained subject to the court's control. Her decision, nevertheless, to access the secure portal, download the files, create backups, print the production, review its contents, investigate from it, and publicly display portions appears difficult to reconcile with the statement and require a sworn explanation. Again, if you are just now joining me, I am reading from ECF 107. It was filed today by the defendant. It's her motion for contempt. Section 2, relevant background. A. Defendant sought protection from identity-focused subpoena use throughout this action. Defendant's objection did not begin after July 10 production. In ECF number 20, defendant informed the court that plaintiff had pursued identifying information through process first styled as a criminal subpoena, falsely implying government involvement, then later reissued in civil format. ECF number 20, page ID 161. Defendant requested protective measures in that same filing, page ID 139. Defendant later informed the court that plaintiff had misused subpoenas and procedural tools in an attempt to unmask and harass defendant. These are the defendant's filings. Her words. Her argument. ECF number 42, page ID 304. Defendant does not ask the court to decide the legality of the earlier subpoena process in this motion. That history is offered to show notice, context, and the need for a sworn accounting. Next, section B. Plaintiff announced that post-judgment discovery would be used to identify defendant. On April 14, 2026, immediately after the damages hearing, plaintiff publicly stated, quote, "We still get to know your identity, homegirl, okay? We still get to know who you are. Exhibit G, Part 1, transcript at 5 minutes, 11 seconds through 5 and 26 seconds. She then announced, quote, "Tomorrow, I'm filing my motion for discovery. So, we about to definitely know who you are, girlfriend," unquote. At the same transcript, 10 minutes, 1 second through the same 10 minutes, 10 seconds. Plaintiff connected discovery to payment. Quote, "Maybe if you write that check quick, you ain't got to go through all that discovery and all that stuff," unquote. Same transcript, 10 minutes, 14 seconds through 10 minutes, 28 seconds. Again, I'm reading for the very first time. During part 2, plaintiff explained, quote, "If she calls herself trying to fight the judgment, I can find out who she is. That's where discovery and all of that is going to come to play." Exhibit G, Part 2, transcript at 2 minutes, 18 seconds through 2 minutes, 38 seconds. She specifically identified Google as a subpoena target, stating that after judgment, she could file a motion and subpoena the banks and subpoena Google AdSense. The same transcript at 3 minutes 11 seconds through 3 minutes 52 seconds. Plaintiff also stated that if defendant paid immediately, quote, then I won't find out who she is, unquote, because, quote, if I try to subpoena Google, they gonna say she already satisfied the judgment, unquote. Same transcript, 6 minutes 11 seconds through 6 minute 33 second. Later, plaintiff stated, quote, tomorrow I'm going to go and going to file for discovery and I'm going to handle my business. I'm doing that ASAP. Same transcript at 14 minutes 12 seconds through 14 minutes 39 seconds. Those statements establish that plaintiff intended Google discovery was directed toward identifying defendant and supporting enforcement of the judgment. C. The court found collection activity premature and warned that Rule 45 compliance would be required. That's the heading of this section. Judgment was entered April 15, 2026. The disputed Google subpoena also bears an April 15th date. On April 21st, the court dismissed plaintiff's motion to compel information allegedly relevant to collection on the default judgment as premature. ECF number 72, page ID 695. On May 5th, defendant filed ECF number 83, challenging the Google subpoena as enforcement and collection related process and stating that defendant had not received proper notice or a meaningful opportunity to object. ECF number 83, page ID 950 through 954. On May 7th, the court dismissed the motion to quash as moot because a stay was already operative and warned that if non-party subpoena issue resurfaced, the court would expect full compliance with Rule 45. ECF number 85, page ID 962 through 963. That order did not determine that the original subpoena was valid. Authorized continued enforcement, approved later service, approved transfer or domestication, excuse advance notice, or authorize plaintiff to access and use a later production while the stays remained active. So Here I see that there was an original subpoena. A motion to quash was filed. Google was thereafter advised that judicial relief had been sought and was provided the relevant stay orders. I had a question about that, or a thought, had they received? Defendant does not identify in this public filing the account, email address, identifier, person, or method through which the materials were transmitted because those details may reveal protected identifying information. Recall, just for conversation and minimal commentary, I said there are things that were stated in the previous documents, and there were things that weren't stated. Here we are, at least I'm seeing something that I had a question about. D. Defendant received no notice of any later operative subpoena. I had a question about that. This is the section heading, all right, or section title for this section. So she's going to get into defendant received no notice of any later operative subpoena. A thought. She used the word subpoenas earlier that I read, plural. She talked about an original subpoena. She's going to be talking about a later operative subpoena. I have a thought about that. I continue. After ECF number 85, defendant received no advance notice or copy of any amended, corrected, renewed, continued, reissued, transferred, converted, domesticated, California replacement, or other later process directed to Google. Defendant, therefore, had no opportunity to determine what process was being used, what information was demanded, when Google would be served, whether Google's objections had been resolved, whether Rule 45 had been followed, whether the process violated the stays, or whether further judicial relief was necessary before production. I have thoughts. We continue. This chronology, this timeline, everything that she is laying out, That's what she's doing. She's laying out events since this default judgment and when the automatic stay was in place and beyond. I'll just say that. That might be apparent, but I'm just making limited commentary. I'm not just reading, all right? I need to make it least minimal. Section 3. Plaintiffs' conflicting accounts require a sworn explanation. The header. Plaintiff claimed she acted during a very small window. That's quoting, quote unquote. She stated that when she had that, quote, small window, unquote, she acted, quote unquote, and was pushing everything. Exhibits B, transcript at 18 minutes 57 seconds through 20 minutes 12 seconds. She further stated that she was paying for subpoenas. This is quote, paying for subpoenas through other states, unquote. And, quote, had to transfer this subpoena to another. I have a thought. This is why I said original subpoena, corrected subpoena. Is this the same subpoena? A rewritten subpoena? Had to transfer this subpoena to another. In the same filing, she also stated, or transcript, that when the judge did not respond immediately, she hurried. When I take pauses, I'm just thinking. Plaintiff also described the later Google communication as an extension from April and said the portal sent her to a private file. Exhibit B, transcript 20 minutes 47 seconds through 22 minutes and 5 seconds. These accounts may describe materially different processes, an interstate transfer or later process, a continuation of the original April process, or some other action. Dots. The appearance of the same federal case number or Google internal reference number does not establish which subpoena Google honored. I'm just going to pause right there for my understanding, because I have been asking, were there separate subpoenas? The defendant continues to refer in a way that I'm thinking that there were two. She says the appearance of the same federal case number or Google internal reference number does not establish which subpoena Google honored. Is that literal? I continue. The transition from Google's objection to production is unexplained. Questions? I'm not asking you for questions. I'm just saying questions. I have thoughts. I have questions. This is going to come down to, though, the court. I'm not a party to this case. I'm reading from these documents. It's on Pacer. I'm not arguing the merits or sharing all my thoughts. That's a question. That's a question. It's a statement. Listen carefully. That's a question. I'm telling you, just my thoughts. Limited. Plaintiff should be required to identify the original subpoena. Here again, she's characterizing or stating original subpoena. That means, is there a subsequent subpoena? That's the way this seems to be evolving or being stated. I'm not a lawyer. I'm reading this. I'm not giving my thoughts on everything. Sorry for continuing to repeat it. It's just that I'm taking time reading this. You might have your own questions. Google's objections. Every response to those objections, every additional document sent to Google, every amended or corrected subpoena, every transfer or domestication document, every service record, every Rule 45 notice, every Google communication, every internal reference number, every portal or production notice, and the exact process Google ultimately accepted. Bear in mind, at the beginning of this broadcast, I did state that the court, and we read from the court's order, said the recourse that the defendant could take was to file a motion for contempt. And that's what we're reading from. That's what I'm reading from. I'm going to read that part again. The transition from Google's objection to production is unexplained. Plaintiff should be required to identify the original subpoena, Google objections, every response to those objections, every additional document sent to Google, every amended or corrected subpoena, every transfer or domestication document, every service record, every Rule 45 notice, every Google communication, every internal reference number, every portal or production notice, and the exact process Google ultimately accepted. That's her argument. That's all of this, the court will decide on that. Plaintiff's small window explanation does not resolve the issue. It makes a sworn chronology necessary. Even if plaintiff identifies a brief interval between particular stay periods, that does not establish that every necessary procedural act occurred during that interval. A claim gap does not excuse Rule 45 notice. It also does not authorize access, downloading, printing, review, investigation, display, or threaten use on July 10th after ECF numbers 93 and 97 were in effect. You have to go back to these and look at those dates, and dates matter. You know what? Dates are going to matter in all of this. The chronology is going to matter. I can say that just as a matter of procedure. Dates and times, especially what the defendant is alleging in the course of these documents. When this happened, why it happened, what did Google say, when did they say it, what did they know, what was the time frame, when were things transmitted, what was transmitted. She's already asking about, it appears, transactional, trans-state localities from Michigan, where it was first filed, to, she mentions California, where Google's, I believe that's their headquarters, and where subpoenas are, necessary to be filed. Just what she's stating. Let's go into the next section 4. Again, limited commentary. Section 4, plaintiff's post-stay conduct was affirmative conduct, not passive receipt. Plaintiff read or described Google correspondence stating that Google would produce documents through a secure file transfer portal, and then stated, quote, "Look, I hurried up and I clicked it. Exhibit B, transcript 8 minutes 30 seconds through 8 minutes 39 seconds. Plaintiff later stated, quote, "Let me hurry up just in case it's a joke," unquote. Same transcript, 14 minutes 14 seconds through 14 minutes 30 seconds. She described the portal as sending her somewhere else to a private file, quote unquote, and stated, quote, "Let me download this," unquote. Same transcript, 20 minutes 47 seconds through 22 minutes 5 seconds. Plaintiff admitted, quote, "I download, back up, did all of that. I also printed it." Same transcript, 38 minutes 16 seconds through 38 minutes 36 seconds. Plaintiff also stated, quote, I printed out everything, unquote, and, quote, they gave me everything, unquote. Same transcript, 13 minutes, 57 seconds through 14 minutes, 6 seconds. Those acts converted temporary portal access into durable electronic and physical possession. Plaintiff described reviewing or possessing subscriber information, account creation information, associated email information, recovery information, telephone information, IP-related information, last logon information, account activity, and two-step verification information. Same transcript, 7 minutes, 42 seconds through 8 minutes, 3 seconds, and 14 minutes, 37 seconds through 15 minutes, 1 second, and 16 minutes, 11 seconds through 16, 19 seconds. 30 minutes, 4 seconds through the same 30 minutes, 23 seconds. Next, 52 minutes and 17 seconds through 53 minutes, 27 seconds. Plaintiff also stated, quote, let me Google this one thing that's on here, unquote, and discussed taking a, quote, deeper dive, unquote, into alleged connections. Same transcript, 35 minutes, 21 seconds through 37 minutes, 18 seconds. How we're doing so far? Let me look at the time. We're at 1 hour 16. You doing okay? Okay. Let me continue. Plaintiff publicly displayed production-related documents during the July 10th broadcast, including a Google-branded document, printed pages held to the camera, electronic text on a mobile telephone, Google legal support communications, an entry dated April 20th, and a legal process subject line containing an internal reference number. Exhibits A-2, A-3, A through D, and Exhibit A-7, A- or A through B, subsections. Defendant does not contend that every word on every displayed page was legible to every viewer. But the public display permitted viewers to pause the recording, enlarge frames, take screenshots, archive the broadcast, and redistribute displayed material. Section 5, titled Civil Contempt and Show Cause Relief are appropriate. A civil contempt movement must establish by clear and convincing evidence that the alleged contemptor knowingly violated a definite and specific order. Banham 93 F 4th at pages 979 through 81. Civil contempt should not issue where there is a fair ground of doubt about whether the order prohibited the challenged conduct, Taggart 587 U.S. at 560 through 63. The present record supports issuance of a show cause order because ECF numbers 93 and 97 were definite stay orders. Plaintiff had actual knowledge. The Google process was enforcement discovery. Plaintiff acknowledged that, quote, the stay was in, unquote. Plaintiff affirmatively accessed, copied, printed, reviewed, investigated from, and displayed the production. And plaintiff contemplated further public disclosure. The court need not make a final contempt finding before requiring plaintiff to provide a sworn explanation and objective records. We are on page 11 of, I think, 14 that I plan to read. An earlier subpoena did not create an unlimited right to use its fruits as the stays. Fruits after the stays. Correction. Plaintiff may argue that the original subpoena was served before ECF numbers 93 and 97. That does not resolve the motion. Here again, the mentioning of the original subpoena. The operative question is not only when the original subpoena was served, it is whether plaintiff continued to conduct enforcement discovery or use its fruits while enforcement was stayed. After those orders, plaintiff made separate affirmative decisions to open the Google communication, click the secure link, enter the private portal, retrieve the files, download the production, create backup copies, print the production, review the contents, investigate information from it, display documents publicly, and contemplate further disclosure. Questions? Answers? So her argument here, I'm just going to emphasize it in this first line. An earlier subpoena did not create an unlimited right to use its fruits after the stays. That argument is her argument. Plaintiff may argue that the original subpoena was served before ECF numbers 93-97. So she puts her argument first and then supposition. Okay. After those orders, plaintiff made separate affirmative decisions to open the Google communication, We read this. Click the secure link, enter the private portal, retrieve the files, download production, create backup copies, print the production, review the contents, investigate information from it, display documents publicly, and contemplate further disclosure. Her argument. Next section, 6. Header, public filing threats and irreversible disclosure require immediate protection. Before I even read that, just thoughts. Thoughts about what is she going to allege here? What is she going to argue here? On the Samantha McLean panel, who's Samantha McLean? Plaintiff stated that if defendant filed anything concerning what Google gave her, it would be a lost cause, quote unquote. On the Samantha McLean panel. Exhibit B-1, transcript 1 minute, 10 seconds through, no, let's look at this closer. This is at 1 hour, 10 minutes, 10 seconds through 1 hour, 11 minutes and 8 seconds. So some panel. Plaintiff then stated, go ahead on file. You filed that. I got that, Google. You go right ahead, and I'm going to attach all the Google documents to Pacer, and everybody can see what I see. Exhibits B, transcript 1 hour, 22 minutes, 2 seconds, 1 hour through 1 hour, 23 minutes, 3 seconds. She added that this was how everybody would know who defendant was and that she was definitely going to attach the material. Same transcript. Oh. Next. Once non-public account. Did I say that correctly? Once non-public account, recovery, telephone, login, device IP related, or authentication information is publicly filed, displayed, downloaded, or redistributed, the harm cannot be meaningfully undone by a later sealing order. Sealing. The threatened injury is concrete rather than speculative. Plaintiff identified the trigger, defendant filing concerning the Google production and the threatened response, publicly docketing all Google documents so others could see them and identify defendant. Once again, I'm reading from the defendant's motion for contempt, ECF 107, filed today, 16th of July, 2026. Did I say filed today? Yes, it is filed today. So it was filed today and docketed. Same date. That's why I paused. Next, the court should not automatically seal anything. Local Rule 5.3 requires authorization and a proper procedure. Notice. The requested relief is narrower. Plaintiff shall not place unredacted Google produced or production derived identifying or technical information on the public docket. That's what she's requesting. Or I should say the defendant in her narrow relief. That the plaintiff shall not place unredacted Google produced or production derived identifying technical information on the public docket. If plaintiff contends that such material is necessary, plaintiff must first obtain authorization under Local Rule 5.3 and submit only the narrowly necessary material through the procedure authorized by the court. That's her request. Next section, 7. Recall separate in a previous broadcast that I made, I talked about legalities, the court. Not in detail. Here, the defendant is making note of certain local rules. Next section, 7. Again, I'm giving limited commentary. It's necessary. I'm not just reading through these documents. Okay, I have to give minimal commentary here. Next section is titled Secure Sequestration and Prospective Relief are appropriate even if the court reserves contempt. So what is she going to argue here? The court should preserve the evidence while preventing additional use. Plaintiff should be ordered to preserve every original and derivative copy, disable public and shared access, place electronic copies in a secure access restricted location, place physical copies in a sealed container, refrain from reviewing the production except as specifically authorized, identify every person who received or reviewed the information, identify every device and storage location, preserve portal and download metadata, and refrain from deletion, alteration, that's different, overriding, concealment, or destruction. Again, I'm reading this for the very first time. Some words, if we read them quickly, might appear to be something like some other word. Next, If the court concludes that the present record does not permit an immediate final contempt ruling, or that the prior stay orders were not sufficiently explicit as to a particular act, the court should still enter prospective relief prohibiting additional portal access, additional downloads, further review, identity investigation using the production, transmission to third parties, public display, public description of non-public content, public filing, threatened disclosure, and deletion or destruction until further notice. This is page 13, so we're getting close here. In bold, defendant is not asking the court to determine on the present record alone whether every challenge act independently constitutes civil contempt. Rather, defendant requests that plaintiff be required to explain those acts under oath, identify the operative subpoena process, and preserve the evidence so that the court may determine whether contempt or other prospective relief is warranted. I pause. My thoughts at first pass, my commentary on this bolded section or paragraph. My thoughts in my own words. It appears that the defendant is asking the court to bring the plaintiff back before her in a hearing and to swear, give a sworn statement. Let me just finish. Give a sworn statement before the court on the record before the court makes a determination on whether contempt is warranted. She says other prospective relief. So contempt and or other prospective relief. So again, this is just my thought right now. It could be all wrong. So that's why I took my time just putting context around before I speak, because I need to give limited. I'm giving this because this is what I understand right now this to mean. I'm not arguing the merits. This is my understanding. This is what I'm thinking. This is what I'm thinking. She's asking that she wants the court to bring the plaintiff back to her courtroom. Now, can the plaintiff give a sworn statement on camera? Yes. So that is my thinking. So let me expand on that. I don't know if this means before, on camera, but whether she has to be physically, at the courthouse downtown, like she was for her default hearing, that would be up to the court if she required this. Whether it could be on camera or a sworn statement, not certain what she is asking altogether. An attorney would have to read this, all of this, and give the legal meaning. What could this mean? If that would occur, would the again, so I'm pausing right now on this bolded one and just asking some questions. Whether or not the plaintiff could then come back, and I'm not going to argue, just saying what are the possibilities here? Don't know all of them. But could the plaintiff then come back and argue? Yeah. This is a motion for contempt. The plaintiff is going to respond to this motion and offer her, response to this, which might very well include her argument as to, all of this, specifically these bolded. I don't know. But it appears that the defendant is asking for a requirement throughout this motion for the plaintiff to respond with sworn statements, and then here in this have those as records by which the court makes their opinion before making giving an opinion, a ruling on contempt. Just stating my thoughts. Don't know. This is legal. I don't know exactly this is my thoughts. I can't even, properly interpret. Interpretation is just that. It's my interpretation. I don't know. But I did want to pause on that one. Interesting. So what I was going to say in the response in this motion, this is just a question. Could the plaintiff, and that's almost rhetorical, ask a question herself? A requirement, if there is a requirement, that there be a requirement for the defendant to appear. I'm just asking questions. I don't know. Let's get to this conclusion. I have to be careful. That part was just my thoughts, statements, not arguing. I'm just sharing, giving commentary, asking questions. Don't know. Conclusion and relief requested. Defendant respectfully requests that the court enter an order, A, requiring plaintiff to show cause under oath why she should not be held in civil contempt for violating ECF numbers 93 and 97. Under oath. That's why. B, requiring plaintiff to identify the precise subpoena or other process Google honored. I still read this. When I read this, that this implies that there were separate subpoenas. So that's how I understand it. An original and a subsequent. C, requiring plaintiff to produce or identify all subpoenas, applications, transfer records, domestication records, service records, receipts, Rule 45 notices, Google objections, responses, correspondence, and production notices. D, requiring plaintiff to identify every act allegedly performed during any claimed gap or quote unquote small window. E, requiring plaintiff to identify the date and time of every portal access. Preview, download, re-download, backup, screenshot, photograph, print out, review, investigation, display, transmission, and proposed filing. Hang on one second. This is an aside. There was an emergency alert here in Michigan and surrounding states, areas. We border Canada. And last night, today, and throughout the day, emergency alerts have been going off about fire smoke that has crossed over to Michigan and other surrounding areas. People have had to go to hospitals and have experienced all kinds of symptoms today. Seriously, breathing, coughing, vomiting, emesis, and other conditions. So when I paused, it's they're doing everything to mitigate it's real going on in this area. I've even closed my windows, turned on air, worn mask. They're telling people to not travel if they don't have to. It's that serious. So my apologies. F, requiring plaintiff to identify every person who received, viewed, accessed, was shown, or was told non-public production-derived information. G, requiring plaintiff to identify every device, account, storage location, cloud service, physical location, and repository containing an original or derivative copy. H, requiring preservation and secure sequestration of all original and derivative evidence. I. Prohibiting further portal access, downloading, review, investigation, transmission, public display, publication, or dissemination pending further order. J. Prohibiting plaintiff from publicly filing any unredacted Google produced document or production derived identifying or technical information absent prior authorization under ED-MISH LR 5.3. K. Prohibiting plaintiff from conditioning, threatening, or linking disclosure to defendant's filing of a contempt motion, objection, appeal, motion for protection, or other resort to the court. L. Allowing defendant to file a reply after plaintiff's sworn response. M. Conducting a remote evidentiary hearing. If material facts remain disputed. And in granting such other coercive, compensatory, preservative, or protective relief as the court deems just. It's signed, dated, Daniel Robertson, and certified of date or certificate of date of service of the foregoing motion. Wow. Hang on. Definitely need to pause there, because what I look at next is, and I'm not, okay, but what comes after this motion are the exhibits and transcripts for emergency temporary restraining order, request and motion to enforce stays, and for show cause, with attachments, 270 pages. All right. She also filed, she being the defendant, also filed her declaration. Another declaration. I'm going to read that. But before I do, I'm going to take just a little bit of a break. And just give me a couple of minutes or so. Before I even look at anything, you can email me right now at unwinewithteddy@gmail.com. It's 9:38 p.m. I've been on just under 2 hours, hour and 53. I'll be right back. Well, I'm back and I'm going to pull up ECF number 108. But before we get into it, let's just see something here. Where is... After knowing that the defendant has filed this motion for contempt, 285 pages, plus a declaration, I think that is 5 pages. Think about this statement. I can file something. This is the statement I read earlier. I can file something today and they can already respond to it, but they cannot, or they're not responding to what I filed back in May. Daniel Robertson, Fair Use Commentary. Just this was a filing that the court put in her order, said this is the recourse that the defendant could take, and it's lengthy. Who knows until the court writes her opinion on what the defendant filed today, whether it's comes back in one day, tomorrow, or it takes months. It's going to be the court to weigh all of this. So far, what you've heard from this motion, what she's arguing, what she's asking the court, and what she being the defendant has put forth in her arguments. Ivy says, I don't think I've ever seen you do a 2-hour live. What a treat for us. You're here. I've done, it's rare. It is rare. But in the beginning, I said, grab a snack. It's probably going to go a while. I came on earlier too. This is, let me just take that off the screen. Before I get into her, it's just 4.5 page declaration. There was a lot in that motion for contempt. She being the defendant, mentioned that in her other motions, in those 4 that the court ruled on and denied, that she had talked about contempt or other issues, but that the court wanted it separated. This is my words, separated out. Yeah. So some of it in the exhibits, I think those exhibits existed or exist, not as if they're not there, exist in prior, there's some records, but what she included now is part of her filing for, this motion for contempt to support her arguments. All right. It's 9:48. Ready to get on to the next? Let me just, are there any? Let me just look quickly. Most people are in the bushes. There might be one or two questions or statements, comments, I should say, that I could throw up. Just see what you guys are thinking. And again, thanks to FIVO early on for the $20 super chat. I appreciate it. Starting up. And hello to everyone. I'm not going to take up too much time here. Want to get through the reading, and then, we can go over comments later. Just scanning. Because most people are here for this. They want to hear what's in these documents. Again, these are her allegations. The defendant, I should stop saying her. These are the defendant's allegations and arguments contained in these filings. Stacy B, hello and good evening. Interesting. I'll put it up there. Again, all comments and opinions belong to the chat and or individual making them. Interesting comment. Good evening, Teddy and mods. Hope all is well. You are typically in the bushes. Glad that you've come out the bushes. Wanted to drop down to say that the cited case law is inappropriately placed and reeks of ChatGPT. Your opinions? I appreciate you sharing your thoughts. Again, it's all allegedly. I haven't confirmed any of these citations. The court will do that with the clerks. Appreciate that. Golden drops in. Thank you. Ooh. All right, let's get on to, and we'll come back with, I see there's lots of comments as I go down in statements. Wow. Let's see. OJ. I did this before. OG. Wu Chow. Hey. Still OJ. Welcome to the Bear Cave. Welcome to Unwind with Teddy. OG. Wu Chow. Glad you could join us tonight. There's a lot in there for an ask. All right. So let's go into this declaration. And let's throw this up real quick. Is this it? It is. This is ECF 108, 5 pages. Same case. Declaration of Danielle Robertson. I, Danielle Robertson, declare under penalty of perjury pursuant to 28 U.S.C. 1746 as follows. Hang on. 1. I am the improperly named defendant in this action. I submit this declaration in support of defendant's motion for an order to show cause and related preservation, and protective relief. 2. I use the captioned name because that is the name used in the case caption. Nothing in this declaration waives any objection concerning service, jurisdiction, party identity, name privacy, anonymity, or appellate rights. 3. This declaration is directed to plaintiff's statements, plaintiff's described conduct, and the subpoena and stay related process issues. 4. I have reviewed and preserved recordings, screenshots, transcripts, docket filings, and related materials concerning plaintiff's post-judgment Google subpoena process and plaintiff's July 10, 2026 public broadcast. 5. I personally viewed and preserved plaintiff's April 14, 2026 public broadcast concerning post-judgment discovery and collection activity. 6. During those April 14 broadcasts, I heard plaintiff state that she intended to pursue discovery, subpoena Google, and banks identified the captioned defendant and act before the judgment could be satisfied. 7. I did not receive advance notice or a copy of the April 15, 2026 Google subpoena before service. 8. A motion to quash concerning this Google subpoena was filed at ECF number 83. 9. Google was thereafter advised that judicial relief had been sought and was provided the relevant stay orders. Pausing to give a comment. Fair use commentary. Recall from the motion that the defendant made for contempt that we just read. There was a statement pertaining to this in that filing. And I believe I may have paused also question, but I'm saying it now. The defendant and or statement, the defendant made comments pertaining to this, but did not identify who, herself, anyone, who responded, who gave Google. How did Google receive those relevant stay orders? I think. Again, I'll read it. She says, defendant says in her sworn statement, Google was thereafter advised that judicial relief had been sought and was provided the relevant stay orders. 10. I do not identify in this public declaration the person, account, email address, identifier, technical information, or method through which those materials were transmitted, because those details are unnecessary to the contempt issue and could disclose protected identifying information. More or less related to what my statement and or question and what was also stated in the motion for contempt. So it's clear here that the defendant did not identify the person, the account, email, so forth and so on, because those details, she says, are unnecessary to the contempt and could disclose protective identifying information. 11. I have not received advance notice or a copy of any amended, corrected, renewed, continuation, reissued, transferred, converted, domesticated, California replacement, or other later Google subpoena or process. 12. I have not received records identifying the precise subpoena or process Google treated as operative when it released the July 2026 production. 13. I have not received proof that advance Rule 45 notice and a copy of the operative subpoena were provided before service on Google. "14. I personally viewed and preserved plaintiff's July 10, 2026 public broadcast. 15. Exhibit B is a transcript of the July 10th broadcast. I reviewed the transcript while listening to the complete recording. The complete recording controls if there is any discrepancy between the transcript and the audio-visual record. 16. During the July 10th broadcast, I heard plaintiffs state that, quote, the stay was in, unquote. 17. During the same broadcast, I heard plaintiffs state in substance that once the court acted, quote, we had to stop, unquote. 18. I heard plaintiffs state that the matter involved a Google subpoena and that Google had sent or released materials to her. 19. I heard plaintiffs state that she, quote, hurried up and clicked it, unquote, while discussing Google's secure production communication. 20. I heard plaintiff discuss Google's secure file transfer or portal process and described taking actions to access the production. 21. I heard plaintiff state that she downloaded files from a private file location. 22. I heard plaintiff state that she downloaded the production, backed it up, and printed it. 23. I heard plaintiff state that she acted during a, quote, very small window, unquote. 24. I heard plaintiff state that she paid for subpoenas through other states and had to transfer the subpoena. That I pause. If that's true, that would make sense. Meaning this transfer of one subpoena and that one would have to be issued. Got it, from that state. 25. I heard plaintiff state that she hurried because the court had not immediately ruled. Again, I'm making comments, and when I've made a comment like that, I'm thinking about procedure, nothing more. Not the contents is true, not that it's true, just procedurally, if it's true. $25. Hang on. I heard plaintiff state that she heard because the court had not immediately ruled. 26. I heard plaintiff describe the later Google communication or production as an extension of April. 27. I heard plaintiff describe reviewing categories of non-public account or technical information from the Google production. 28. I heard plaintiff discuss further investigation based on information she said appeared in the production. 29. I observed plaintiff display a Google branded document during the July 10th broadcast. 30. I observed plaintiff hold printed pages toward the camera during the July 10th broadcast. 32. I observed plaintiff display Google legal support communications and a legal process subject line during the July 10 broadcast. 33. Exhibit A contains screenshots that fairly and accurately depict portions of the July 10th broadcast as I viewed them. 34. I do not contend that every word on every displayed page was legible to every viewer. 35. The displayed materials could nevertheless be paused, enlarged, screenshot, zoomed, archived, extracted, or redistributed from the public broadcast. 36. In a later recording, I heard plaintiff make statements indicating that she was not releasing or divulging additional Google-derived information because an active stay remained in place. 37. I do not offer plaintiff's statement as a legal conclusion about the scope of the court stay orders. I offer it as evidence of plaintiff's knowledge, understanding, credibility, and reason for acting. 38. I also heard discussion concerning the possibility of attaching Google-derived information to court papers so that it would become publicly available. 39. I have preserved later statements connecting threatened public filing or disclosure to defendant's decision to report the alleged stay violation or seek contempt relief. I'm gonna read this one. There's something in there. I have preserved later statements connecting threatened public filing, or disclosure to defendant's decision to report the alleged stay violation or seek contempt relief. Just a pause on that question. Just a thought. Question, statement. I haven't listened to all these filings. I haven't listened to all these videos. I haven't. No one need put anything in the chat. A thought comes to mind as to whether there was any statement connecting any public filing threatened that had to do with seeking contempt relief. I'm just pausing to give my needed commentary or statement, question, thought. 40. I request that no unredacted Google production or production derived identifying or technical information be placed on the public docket unless the court first authorizes an appropriate sealed, redacted, or in-camera procedure. (41) I have not received plaintiff's complete subpoena records, transfer records, domestication records, Google communications, portal records, download records, backup records, print records, browser history, device history, recipient lists, or storage records. Pause. Fair use commentary. In the statement, in her sworn statement, plaintiff, here she states, I have not received plaintiff's complete subpoena records. Does that mean she's received subpoena records? And if so, from whom? These are just my thoughts and commentary. One might ask, one might think based on this, but it's going to be up to the court to, if needed, any questions or, the parties involved to reconcile these. This is interesting. Because recall, I'm going to come back to 41. In 10, she says, I do not identify in this public declaration the person, account, email address, identifier, technical information, or method through which these materials were transmitted because those details are unnecessary to the contempt issue and could disclose protected identifying information. All right. I have not received plaintiff's complete subpoena records. Has someone else received? The person that transmitted responded, did someone else? Because they haven't been identified. I don't know. I'm just having thoughts. The defendant in her sworn statement says, I have not received plaintiff's complete subpoena records. Has the defendant received incomplete subpoena records? And if so, from whom? I'm just having thoughts. That's all. Just thoughts. 42. I do not know which subpoena or process Google ultimately honored. 43. Those facts should be reflected in records and communications within plaintiff's possession, custody, or control, or in records available from the relevant subpoena and production process. "44. I request preservation, secure sequestration, a sworn accounting, and prospective protection against further public disclosure or using," that's not what that word says, "or use pending the court's review." 45. The statements in this declaration are based on my personal knowledge, my review of the referenced public recordings, screenshots, transcripts, docket filings, and the materials I preserved. I declare under penalty of perjury that the foregoing is true and correct. Executed. Today's date, the 16th. Let me just put this. It's 10:17. And there are 270 pages that remain unread, which contain a lot of transcript, posts, screenshots. There's a lot in those pages in support of the defendant's motion for contempt. What say you? Now I got through all of that. There's a lot in here. I could make a statement such as, after listening to the contents, these filings that I've read, after hearing them and listening, and after I've read them, this is my first time. So especially, I mean, I'm not legal. This would take legal expert. It can be answered by pro se, and these parties are pro se. So especially in this case, when it comes to something like this, the understanding, it is so nuanced. It's so nuanced that some of this is, it would be, how do I want to say it? It wouldn't be unexpected to misinterpret a nuance, if that makes sense. Because some of these things that are worded, there are some nuances in it. And because all the information isn't present, you're working, what the defendant is asking for the court, and then asking for, sworn statements too. And this is what she's asking for in this document. There would be no wonder. Here's just my opinion. There would be no wonder something could be misstated. I'm not talking about the defendant. I'm just talking about response. To get to go through this. And then my other second statement would be, no need to answer, but you've heard my broadcast. Does it make sense just knowing what's in the contents of these filings so far? Why I may say that, what I've said about this, the discipline, and for myself. Because if you go through these and look at these exhibits in there, she is documenting everything for future. That's why it might take me a long time to get out one sentence, because I'm trying to give it some thought. So, thank you, Stacy B, for the $19.99 super chat. I appreciate that. Let me just, I overlooked it here. I see it just came up. For supporting this channel. Let's see. Stacy B. Chillin says, for some top tier throat lozenges, because that was a lot of chat GPT, repetitive mumbo jumbo to read, Miss Debbie. Thank you. I do have some lifesavers. I don't even know I didn't grab. I have a whole bucket full of lifesavers. Oh, here we go. I keep them by my desk. Yeah, thank you. Yeah, it was a lot to read. And one pass of it Doesn't mean I understand anything. Yeah. Yeah. But I think it's important, as I said in the beginning, to read, because without even understanding or knowing what was written in the documents to properly, I think, discuss, anything that has to do with this contempt motion, it would behoove others just to get a sense of where this defendant, her position, her thoughts. There's a lot in this. Mm-hmm. Yeah. Thank you. Thank you very much for your generous support. Thank you. And you can best believe throat lozenges are in order. I know. That's why I said it before I even came to this. Not lifesavers. I know. Used to pass the mint lifesavers. I like spearmint. Down our whole pew to me and my brothers at church, so no one had bad breath before communion. Oh wow. Okay. Before I jumped to read, I should have read ahead, but that's a memory, isn't it? Don't like the peppermint ones. I'll eat them, but I prefer the spearmint. Yeah. But I thought you were going to say, like, not the lifesavers. I should have read before speaking. All of it. The throat lozenges. Like, lifesavers help, but throat lozenges really soothe. Yeah. Thank you. Appreciate that. Memories are to be treasured. They are. And that's what, that's wonderful memory to have. Yeah. As you can picture it. Yeah. All right. Let me check my email. And I think I can wrap it up. We've yes, I've run over, but it's still early. And I knew that this was going to be kind of lengthy. So I appreciate all of you for joining me. One other thing, before I forget, this could be part of a close. It's not going to happen tonight. There much has been said here. I want to make sure I don't pull up the wrong thing. It's interesting. I'll just say the defendant has made some comments about this recently. And I will show you what I'm talking about. We're not going to get into it tonight. I don't even know if, but here it is. So the court has released the transcript of the motion hearing April 14th, 2026, in the case of Kimberly Smith versus Daniel Robertson. Recall that motion hearing for default motion hearing. Both parties could be present. The plaintiff was present. The defendant chose not to be present. And in multiple motions that were filed by her and reasons given and asked for other methods of appearance, decided not to appear, although the court still expected the defendant to appear. That was her choice. That's my commentary on that. But the motion hearing April 14th before the Honorable Lori J. Mickelson in the United States District Judge, that transcript has been released and it is now public on Pacer. Okay. One other thing. Well, there's lots I could say, but I want to make sure because I know they're listening. So I'll state it like this. I gotta be careful and just state the facts. The defendant made statements pertaining to ascertaining these documents and monies that she stated that she had to pay for the transcripts in preparation for the appeal. All right. To the court reporter, the transcriptionist. Mm-hmm. And there is procedures in place. There are. Okay. I'm not going to say if it's right or if it's wrong. That's not what I'm about to say about anything. It was her choice to proceed in that manner. There were mention of this I'm going to paraphrase. Persons who would obtain the transcript waited. Whoever waited for it to become available. All right. And that in so many words, this is in so many words, that it's because of what she did that would then make it possible. These are my words. For such transcript to be on record. I'm just making statements. That's no true false, no. Except that when I say this is what I understand, or it's there in statements, all right? In so many words. After the defendant received the expedited, I believe that's how they were characterized, transcripts, and for the reasons, those transcripts, the transcript that you see here, was then placed for viewing on a social media platform, and for a fee initially of $100, a person could pay and view them. I'm not here to say whether it's right, wrong, and now they are available. If someone wanted to wait to not have to pay, if that was their choice, this is just my commentary. And if a person decided that they wanted to pay out of pocket $100 to an account, a social media account that was provided the transcript that was promoted allegedly, these records are there. Okay. I'm being very careful because anything that I say could end up being part of the record. So I want whatever is going to be part of the record, including the full transcript for the court. I want it to be known that I want to be accurate, court. I don't want to say anything that's not facts, Your Honor. I don't want to misinterpret anything. I'm not accusing anyone of any wrongdoing. I'm just talking about procedure tonight. That's all I'm talking about is procedure. That's it. Records. So the transcript was offered for viewing, allegedly. And there are records, even though they've been deleted, allegedly, of posts, allegedly, and directives where someone could find them. Allegedly. Whether it's members or not. Allegedly. And who's to say when records are, public and then or put behind a paywall and or put on an offering, how much was collected? But that's okay. It's all right. I'm not here to. So the only thing I'm correlating or trying to think about, see, I'm just telling you what I think and what I'm thinking about. When I read a post today or whenever it was posted about a transcript and the almost $500 someone paid, they said they paid, and I'm sure I'm not disputing that. I'm not even questioning that because there are procedures. But there are fees if you want to expedite them. There was a scale, like you could pay if you want 24 hours, say, for example. You could pay if you want 1 day. You could pay if you wanted to wait a week. You could pay, there's different tiers. That's what I'm trying to say. So if someone paid top tier, that was up to them. That's their right. But I'm trying to be really careful because if you're listening, Your Honor, in case you get these, I'm not here to dispute that, but to be challenged why someone would want to wait for the court to release the documents and not pay. That doesn't necessarily mean that's their choice too. If they wanted to wait the 90 days, wait it out. They could wait it out. There were all kinds of options. Another option for viewing straight away is you could physically go down to the courthouse and sit and read, not print out. And so I made it known, I have to go down to the court to make filings. There was no rush, but because of the length of the transcript, I knew that at some point before the 90 days expired, that I could view the records. I don't think when I say this wasn't directed, the message at me. It was directed at, I'll just say, whoever would read. Yeah. But that was a person's choice. If the person, I'm sorry for so curious to know what was in what the plaintiff said. And there were a lot of comments leading up to that and recordings that were made about it. Talk about it. And if that was enough to entice or persuade one or two or three, or let's say 5 people paid $500 as a total, paid $100, then wouldn't that $500 wipe out the $500 that was paid? I said if she received it. So allegedly the defendant, I'm just doing kind of cash register, you go through the line and you say you paid $500. Okay, ring it up. Well, it's not that you can get a return, but if then later those documents are used before the time, I mean, you can do whatever you want. But one could argue that if the money was recovered, it almost negates the lamenting of a spend per se. I don't know. That's just my commentary. People could do what they want to do. They could pay $2,000. I don't care. I'm not counting because we don't know. All we do know is that there was at some point $100 to view. Like pay-per-view, $100. And if this ends up before the court, I'm not questioning whether someone did something wrong or right. That's not the point at all. But there was a lengthy post made about spending almost $500. And that's okay. That's enough of that. Anyway, the documents are now on Pacer. Okay. The full 56 pages and line by line. Appearance for the plaintiff, appearing pro se, Kimberly Smith. And then I didn't want to show any address, but I'm just rolling up where the line for the pro se it was. Let me just cover this up because I want to tell you what it was. For the defendant, there was this. Let me see. No appearance. That was also her choice. That's procedural. That's all I want to talk about is procedure. All right. Anything else before I say goodnight? I want to just keep it to the facts. That was my commentary tonight. Very, very limited. Let me just read through this. Oh, let me take this cover off. I'm so sorry. Here we go. And let me just put up these last comments. I'm looking through the comments here. Oh, well, thank you so much for the super chat, Stacy B. 1999. Thank you. The opinions. Okay, some I will read and some okay. Not lifesavers. Yes. Okay. Thanks again for everyone. Ivy says, I remember you telling us that. Yeah. Oh. Everything that I've said is alleged. Everything you say is alleged. Let's see. We've got a comment from Ivy Jacinta who says, again, this is all alleged. The platform was free for 30 days to new subscribers, and she had to get it back before the days ran out. Okay. Oops. Let's see. Thank you for your engagement and respecting the platform. Thank you. You're doing your best. That takes us to the bottom of the comments. Oh. I'm just looking at emails. One more song and then we'll be right back. Did I play this one before? I think so. Make this a short break. Very fast. right, so I was trying to put up the goodbye and bear, and I can't kind of scroll it up. Anyway, biggest bear hugs go out to all the grizzlies and the honey bears. Um, please hit the like on your way out and join me sometime when I come back, maybe tomorrow. But I hope you enjoy the rest of your evening. Yeah, that's it. Thanks to my moderators and thanks to all of you who contributed and supported this channel. Again, fair use commentary, everything heard tonight, all alleged, and we try to get the reporting accurate. That's it. Thanks for watching. Until next time, I'm Teddy. Good night.